Major breaking news out of the United States Court of Appeals for the Fifth Circuit down there in Louisiana and Texas. A 3-judge panel has just found that suppressors, silencers, are not arms under the text of the Second Amendment. The right of the people to keep and bear arms, suppressors, silencers are not arms, and thus the Second Amendment challenge to an NFA criminal conviction was no-go and failed. Let's get into it right now, whether the court got it right. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the winner of the 2025 Gunnies Award for the top voice of the Second Amendment. Thank you for your support and that great honor. I really appreciate it. All right, folks, we got to get into this quick. The U.S. Court of Appeals for the Fifth Circuit down there in Louisiana and Texas in a 3-judge panel, in an opinion written by Jennifer Elrod, Chief Judge of the Fifth Circuit, has found 3-0 that suppressors are not arms. This is wrong. This court is wrong. They got it wrong. Period. Full stop. Let's break it down. Okay. To begin with, this case arose from a law enforcement raid on a home and a place of business by George Peterson. The name of this case is the United States of America versus George Peterson. Mr. Peterson apparently pled guilty to possessing an unregistered suppressor in violation of the National Firearms Act. On appeal, he challenges his conviction on various grounds, including, in particular, Second Amendment grounds. He said his indictment should have been dismissed because suppressors are protected arms and there is no historical basis for banning or otherwise restricting suppressors as an arm. Now, what the judge did here, the 3-judge panel said, is they start off by pointing out the test, if you will, of Heller and Bruin, of text first, burden shifts to the government, and then a historical analysis to see if there's a long-standing historical tradition of firearms regulation that would be applicable here. But here, arguably, what we're dealing with is there's 2 potential problems here with what this NFA regulation is. The first is, to the extent this is an arms ban, guess what? An arms ban cannot stand if the item being banned is in common use by Americans for lawful purposes, because it would violate the Heller 2008 decision by the Supreme Court that says, based on the historical tradition of regulation of firearms in America, the only types of weapons that could conceivably be banned are those that are dangerous and unusual conjunctive, and if an arm is in common use by Americans for lawful purposes, cannot be banned because it cannot be dangerous and unusual, a conjunctive test. So to the extent that suppressors today are arms, and this is viewed as a ban on a type of arm, i.e. suppressors, or firearms that fire with suppressed arms, or suppressed sound, if you will, then Heller applies, and there's millions and millions of suppressors in American life. There's no dispute about that. You can just look at the NFA data under compiled by the ATF, and there's millions and millions of suppressors registered under the NFA alone. So they're in common use. So under an arms ban analysis of Heller, the ban on suppressors should go away. But of course, this presupposes that a suppressor is textually an arm in the first instant. To the extent this is viewed as a regulation of arms, there is no history of requiring a regulation or a tax on an arm. In fact, to the extent that a suppressor is an arm textually, which we'll get to in 1 minute, then a tax on a constitutionally protected item, such as a targeted tax on a firearm, would be unconstitutional under the Second Amendment, based on Supreme Court precedent of Minneapolis versus Starr, U.S. Supreme Court case in the early 1980s, and Harper versus Board of Elections from the 1960s that said a $1.50 poll tax is a no-go zone. So, and of course, there's no history of taxing firearms or ammunition or anything of the like at the time of the founding, 1791, when the Bill of Rights and the Second Amendment was adopted, which is the key time period to try to figure out what did the Bill of Rights meant? What did it mean? Well, you look at it at the time of the founding. When it was adopted, what did people think it meant? That's the idea. So no matter how you look at this, whether this is an arms ban case under Heller, or it's some sort of a gun-related tax under Harper or Minneapolis Starr, or it's just some sort of a regulation registration requirement under Heller and Bruin methodology, no matter how you look at it, this all turns on a fundamental assumption that a suppressor, or that bans or regulations on suppressors, somehow implicate the text of the Second Amendment. And the answer is it does. Although this court got it wrong, and we're going to show you why in a second. Remember, the text of the Second Amendment, the right of the people to keep and bear arms, shall not be infringed. The argument here is that a suppressor is an arm under the text of the Second Amendment. But this court said, no, it's not true. The court started down the right path by quoting the definition of arms in the Heller case. So at least they went to the Supreme Court precedent of Heller to start their definition of what is an arm, but then they got sloppy. So let's just start off with where they go with the definition of arm in Heller in this opinion of U.S. versus Peterson. The Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding, quoting Heller. And as both parties agree here, arms in the Second Amendment sense comprises weapons of offense, armor of defense, and anything that a man wears for his defense, takes into his hands, or useth in wrath to cast or strike at another. That is, to constitute an arm, the object in question must be a weapon. Okay, that's sort of right, but not entirely. But let's begin with the analysis. Remember what I've taught you before. Before we analyze a suppressor in and of itself, let's just talk about the big picture here. What is the effect of regulating a suppressor or banning a suppressor? Now, this court panel laser focused it on the item. In fact, they literally made funny jokes, so they think about how a suppressor by itself is not a weapon. Here's what the court writes, but then it's going to boomerang back on them. But begin with, let's see what the court writes about why suppressors in and of themselves are not weapons. The defendant Peterson posits that suppressors are an integral part of a firearm and therefore warrant Second Amendment protection. Inasmuch as a bullet must pass through an attached suppressor to arrive at its intended target, suppressors are used for casting and striking and thus fit Heller's definition, but that is wrong. A suppressor by itself is not a weapon. Without being attached to a firearm, it would not be much use for self-defense. And unless a suppressor itself is thrown, which of course is not how firearms work, it cannot do any casting or striking. Instead, we agree with the 10th Circuit that a suppressor is a firearm accessory, not a weapon. And while possession of firearms themselves is covered by the plain text of the Second Amendment, possession of firearms accessory is not. Accordingly, Peterson has not shown that the NFA's registration scheme burdens a constitutionally protected right. No. Because if you ban or regulate a suppressor, what have you done? You have banned or regulated a firearm capable of firing suppressed rounds. Hear what I just said? You have banned an entire category of firearms in American life if you ban or regulate suppressors, because you are preventing and banning or regulating firearms that are capable of firing suppressed rounds. Thus, obviously, you are regulating, restricting, or banning the use of a particular type or category of firearm. In the same way in Heller in 2008, when the Supreme Court struck down the Washington, D.C. handgun ban, the Supreme Court says you cannot ban a category of firearm that is in common use by Americans for lawful purposes. In D.C., in the Heller case in D.C., that category of firearm were handguns. But in this case of United States versus Peterson, the category of firearms being banned and or regulated and or restricted, whatever word you want to use here, gets you the same outcome. In this case of Peterson, are a category of firearms capable of firing suppressed rounds. So it is a gun ban or gun regulation. And because it is a gun ban or gun regulation, it is by definition of necessity an arms ban or an arms regulation. And does the word arms appear in the text of the Second Amendment? Well, let's see. Oh, yeah, it does. The right of the people to keep and bear arms shall not be infringed. So if you have a regulation or ban on an entire category of firearms capable of firing suppressed rounds, you have hindered the ability of people to keep and bear arms that fire suppressed. It is a firearms ban or regulation, which means the text of the Second Amendment has been implicated by the modern-day gun control law, and you must do the analysis. And when you do the analysis, once the text is satisfied, whether it's an arms ban under Heller, whether it's a tax under Harper and Minneapolis Star, or just a straightforward regulation under Bruin, where there were no taxes or these kinds of regulations at the time of the founding, the suppressor argument should win on a Second Amendment challenge. But let's go beyond that and analyze further and point out other mistakes made by this three-judge panel. So here's the thing. They want you to analyze the suppressor in a vacuum, right? That's why they make these kind of jokes. A suppressor by itself is not a weapon. Okay. In one sense, that's true. But have you answered the question correctly under Supreme Court precedent? Has this three-judge panel read carefully the Bruin decision? Well, maybe or maybe not. Why? Because it's a critical sentence that you would find in the Bruin decision in 2022 by the United States Supreme Court, which last I checked in the U.S. Constitution is the superior court to the inferior court of the Fifth Circuit. Now, what does the U.S. Supreme Court say about instruments that facilitate self-defense? Oh, yeah, there's a specific line that speaks to this issue. In Bruin, it says that an instrument, here what I just said, very specific word. The court did not say weapon. The court did not say arms. The court said instrument. It said an instrument that can or does facilitate, which means help or enhance or aid. Armed self-defense is protected under the Second Amendment. An instrument that facilitates self-defense, armed self-defense, is a protected arm. Well, does a suppressor, is it an instrument? Hello, of course it is. A suppressor is an instrument. It's an item that does a job, so it's an instrument. Okay, so the question is, does the use of a suppressor facilitate armed self-defense? Hello, of course it does. In many ways. In one sense, it facilitates training so you're able to effectuate your right to self-defense because it's a lot easier to train with suppressed rounds that don't hurt your hearing. And by training, you're more likely to succeed in a self-defense situation, which means, again, you've used an instrument, a suppressor, to facilitate armed self-defense by improving your training. Beyond that, if you're in a home or a self-defense situation, firing suppressed rounds, you're much more likely to use the weapon effectively if you don't have to worry about going deaf if you touch off a round, or making a family member deaf if you touch off a round, or giving yourself or a family member or someone else in your presence tinnitus. Very dangerous. Some people have killed themselves, or I should say self-delete themselves because of tinnitus. It's how terrible it is as a disease, which you can get from loud noises being heard. Not a good thing. So obviously, no matter how you look at it, a suppressor is an instrument that facilitates self-defense. But beyond that, let's take a look. So you've already seen multiple errors by this panel, but let's go on beyond that. The whole logic of this panel is faulty. They're arguing that it has to be necessary, essential, right? It's saying that a firearm does not need a suppressor to function. That's right. It specifically rejects the suggestion that a suppressor is an integral part of a firearm, which means a necessary component. But that's not the question. That's the wrong question. You see, there's a lot of things that facilitate armed self-defense or are instruments that help facilitate armed self-defense, a la the language in Bruin, that in and of themselves are not weapons. Let's just think off the top of our head. Ammunition, a round, a bullet. I mean, any of these things by themselves are, right? They're not weapons in and of themselves. I can throw a bullet. I can throw a round, right? I can throw a cartridge. That's not a weapon. So under this logic by the Fifth Circuit, I suppose ammunition would not be viewed as an integral part of a firearm because it's not itself a weapon. How about a pistol grip? I mean, I can touch off a round with any kind of a rifle or even a handgun in a sense. Without a pistol grip, it might not be as effective, right? But a pistol grip is not necessary for a firearm to function as a firearm, right? So does that mean a pistol grip can be banned? Likewise, a scope. Again, I can touch off a round without a scope. A red dot, I can touch off a round without a red dot. Anything that magnifies, again, I can touch off a round with any kind of any kind of magnifying accessory or tool or whatever you want to call it in the language of the Fifth Circuit here. Same with the magazine, right? If you think about it, you don't need a magazine to touch off a round, right? Many firearms will fire at least a round without a magazine in it. That's why you get the warning that says, this gun will fire even without a magazine. So be very careful. So all the things I just said really demonstrate the fallaciousness of the logic here that basically says it is simply wrong to suggest that a suppressor in and of itself is a weapon, and as a consequence, because it's not a weapon in and of itself, it cannot be protected as an arm under the Second Amendment, but that's simply wrong. It violates the Supreme Court's precedent of Bruin that says that an instrument that facilitates armed self-defense is protected as an arm. It just violates the fact that, there are things that are helpful to firing a firearm accurately to effectuate your right to self-defense, not least of which is ammunition, bullets, magazines, pistol grips, and the like. And a suppressor is all of the above. And it ignores the most logical concept here that, again, a ban or regulation or a tax on a suppressor is the same as a ban, is same as a regulation, is the same on a restriction on or a tax on a firearm that can fire suppressed rounds. In the same logic that if you ban magazines that hold more than 10 rounds, what you have effectively done is you've banned an entire category of firearm. Those are firearms that are capable of firing more than 10 rounds without being manually reloaded, and that is a ban on an entire category of firearm, which, as we know from Heller and the DC gun ban, is verboten and not allowed. But no matter how you look at this, the reality is that a suppressor ban or restriction basically functions as a restriction or a ban on an arm, and thus the text of the Second Amendment is indeed implicated. And because the text of the Second Amendment is implicated, because you're dealing with a law that hinders the ability to possess, keep, or bear arms, i.e. a firearm with a suppressor on it, okay, you have to do the analysis either under Heller, under the Bruin methodology, in terms of text first and history second, or under Minneapolis Star and Harper dealing with taxing cases and constitutional rights and those targeted laws that target constitutional rights. Either way, we should win these suppressor cases. And of course, the last and in some ways most obvious point is that the National Firearms Act itself provides that the term quote unquote firearm means any silencer as defined by the Gun Control Act. That's right. Literally, the National Firearms Act, which is what is being dealt with here, defines firearm to include any silencer. Seems like pretty strong evidence that silencers are arms under the Second Amendment, but I'll let you be the judge. But this decision by the U.S. Court of Appeals for the Fifth Circuit is wrong. It's analytically full of several errors, and I'm a little surprised this came out of the Fifth Circuit, but they clearly did not fully appreciate the different points that I'm making on this video, and maybe something will change down the road because I think the Supreme Court would agree with me and not with the Fifth Circuit on this point. But again, the history of the future has yet to be written. All right, folks, there you have it. I hope you enjoyed today's show. Make sure you follow me on X at 4boxesdowner. Don't forget to subscribe both on Rumble and YouTube. We're trying to get to 200,000 subscribers on YouTube, and we're trying to get a more significant presence over there on Rumble, which we just turned that on a couple months ago because a lot of people prefer Rumble for various reasons. And again, I appreciate your support. I look forward to talking to you again very, very soon here at the 4 Boxes Diner.
Orders up. Table 2A.